Sir Williams, CEO.
Thank you, Mr. Chairman. I'm excited about taking a call on this, bill, and I want to confine my remarks to the purpose clause, and then I want to also make reference to Part 2, Subpart 3 on community magistrates. I also want to speak on my colleague Louisa Ward's supplementary order paper 217. But before I do so, sir, I want to say that I think by and large this House welcomes the review and the updated legislation. It has been for about 100 years since the existence of the original Act, and therefore I think, generally speaking, most of us are trying to ensure that we get the best legislation out of this. And I'm glad and I hope that the government does take its time in ensuring that this process is given due consideration by all parties. I want to make reference to Part 1, and particularly purposes, sir, because I understand that in the review by which this bill is based on, it had the Supreme Court Act of 2003. There was reference to a couple of key principles that are missing from the purpose of this bill. I note in Clause 3, Part A, Part 2, it makes reference to practice and procedure, but there's nothing in the interpretation clauses that makes reference to those practice and procedure. My reference, sir, is that in the Supreme Court Act, it made reference to the rule of law. It made reference to the Treaty of Waitangi. And I think there's also needs to be a reference to the sovereignty of Parliament as well as to judicial independence. It seems to me that we are expunging some key elements that should underline our court systems. And I'm not sure what the government's intentions are. I did understand that in the second reading speeches, the minister said that these principles or these elements would be included in our Constitution. But if that's the case, sir, why are we not then amending the Constitution before we do this? So that's the first question I want to ask. I also want to ask the Minister, see, the government is calling this the Judicature Modernisation Bill. The removal of that key element, the removal of our emphasis of abiding by the rule of law is not a good look for us on the international scene, particularly in our relationship with what's happening in Fiji. You know, in this day and age, modernisation means that we have to, more than any other time, re-emphasise our commitment to these core principles, core elements that should underline our court system. I refer, sir, to Clause 38, Miscellaneous Matters, Subclause 6. And I simply ask, there's a reference there that anybody can ask the judge to detain somebody that is leaving to go overseas. And if proved to that judge, that person can be detained. But then in Subclause 6, it says that a defendant who is remanded in custody must be brought before the court within 4 days after the date of the order. I'm simply asking, sir, why 4 days? Why not be brought before the court immediately? I only say that, sir, because the experience of some of our constituency where they have been detained whilst they are on an urgent matter, whether it be a funeral in Pakistan or India, the detaining of this person before they're able to go before the court for those 4 days means that they miss the urgency of the matter that they were travelling to. I'm not talking about whether they have able to justify for the warrant for them being detained. I'm talking about, shouldn't that person being held in prison, should they not have the right to immediately be brought before the courts and not be held for 4 days? I want to refer, sir, to Subpart 3, Part 2. This is community magistrates. I want to ask a question. in Mr. Chairman,
The Honourable
Mr. Chairman.
Wagner.